Chapter 3, Legal Issues, Part 8. One quick word about Miranda before we get to the exclusionary rule. Again, I want to emphasize the Miranda warnings only have to be read when the police are going to engage in custodial interrogation. So if the person is not in custody when the police are questioning, meaning that the person realizes that they're free to leave, then the police have not engaged in custodial interrogation and they don't have to read the Miranda warnings. If the police come to your home and you invite them in and they sit down in your living room and you're serving them coffee and whatever, and they're asking you questions about a crime, that would not be perceived by the courts as custodial, because surely you know that you're doing this voluntarily and you could walk away from it, and et cetera, et cetera, et cetera. If you offered up information about criminal activity that implicates you in that kind of setting, in your home, in your living room, then if the police failed to read your Miranda warnings, it doesn't doom your case. But if you're, especially if you're brought into a police headquarters, or the police have you in handcuffs in the back of a police car and they're asking you questions, well, that's definitely custodial interrogation. So there are some gray areas where we have to ask, was it custodial or not? But the police don't have to read Miranda warnings just because they asked you some questions. It has to be custodial interrogation. It has to be that you are now no longer free to leave. And if you're in that setting and they're asking you questions, then you have the right to an attorney, you have the right to remain silent, and you always have that right anytime, but the police have to advise you that you have that right. And so this is why, if you're watching Cops, or you're watching, some other show like that, they often don't read the Miranda warnings. And in fact, when Miranda was first decided, many police officers thought this was the end of policing. And they thought, we'll never get another confession, because why would anybody talk to us? Well, it's been over 50 years since Miranda, and policing hasn't died away, and police are still getting confessions and convictions. And if you think about it, for most crimes, we don't need a confession. I did police ride-alongs with the Richmond police for a whole summer, and I've done a lot of other ride-alongs and a lot of other studies of the police, and I don't think I've ever heard them read the Miranda warnings, because they didn't need to. If I'm a cop and I catch you for drunk driving, do I really need to have you tell me that you're drunk if you're slurring your words and you flunked the sobriety test? No. So for most criminal actions, we don't have to call out CSI to figure out what happened. It's pretty clear. And so therefore we don't need confessions. And so Miranda hasn't really stopped people from giving confessions when confessions are helpful. And for the bulk of the other crimes, we don't need confessions. So it wasn't surprising to a lot of people that in the early 2000s that one of the most conservative Supreme Court justices actually upheld Miranda. A lot of people thought he might get rid of it, but there were a lot of people who weren't surprised when he wrote the opinion that upheld Miranda and said there's no reason to get rid of it. Well, when somebody like that, and it was Chief Justice Rehnquist, when a person as conservative as Chief Justice Rehnquist says, Miranda's okay, it's not stopping people from confessing, and it's not handcuffing the police. And so, that's kind of the legacy of Miranda. I had some professors who were New York City police officers back in the 60s when Miranda was decided, and they said that back then the judges would really, really question the police officers and their actions when a suspect confessed, because they couldn't believe that somebody would confess after being told you don't have to. But as we often see in real life, people want to talk. And even if you tell them they don't have to talk, they'll still talk. And it's often hard to get them to shut up rather than to get them to talk. And today, judges don't really question police that closely when somebody confesses, unless the defense attorney raises an issue. So Miranda, it's not seen as any kind of handcuff on the police today. It was when it was first decided. Okay, what happens if the police do violate somebody's rights? Maybe they do fail to read the Miranda warnings when they should have, or they illegally search somebody, or they violate some of these other rights that we've been talking about. Well, the Supreme Court decided in 1914 that if there's a violation of the Fourth Amendment, or even the Fifth, or maybe the Sixth with the right to counsel, that the exclusionary rule is the way to respond to it. And so initially, this was before incorporation, the exclusionary rule only applied to the federal government. So the Constitution doesn't tell us what to do in case there's a violation. But the Supreme Court in a 1914 case said the best way to punish law enforcement if they violate someone's rights is to not allow them to use the evidence that they found as a result of this violation. And so the exclusionary rule is what the Supreme Court came up with, and it's meant to discourage bad police behavior. Eventually, the exclusionary rule was incorporated and applied to the states in the famous 1961 Mapp versus Ohio case. So today, the exclusionary rule will apply to both state and federal action that violates the Constitution when it comes to criminal defendants' rights. The effect of the rule is that the government will not be allowed to use any evidence that it obtains through these illegal means. So if they illegally search a person and violate that person's Fourth Amendment rights, that evidence will not be allowed to be used against the criminal defendant. It'll be suppressed. The defense attorney will file a motion and say that this was obtained in violation of the client's rights, and the judge, if the judge agrees, will not allow that evidence to be used. So all that hard work that might have been done by the police, if they violate the rules, they're not going to get the advantage of that work. If they violate the Fifth Amendment, if they force somebody into a confession, or they fail to read the Miranda warnings before they question the person when they should have, any of these things, or the violation of the Sixth Amendment, they don't allow the person to speak to their attorney. Again, any information, testimonial information, or any physical evidence that's found won't be admissible in court because of the police violating the person's rights. An extension of this is something known as the fruit of the poisonous tree. Because not only will the evidence that was at the very core of the bad search, the bad interrogation, or whatever it might be, for the purposes of our illustrations, I'll only talk about searches from now on, but it also applies to confessions and other violations. But whatever is found immediately will be excluded under the exclusionary rule. But a branch off that exclusionary rule is the fruit of the poisonous tree doctrine. And it says if the police use that bad evidence and that bad search to find additional evidence, even if they subsequently do comply with the law, they get a search warrant, they have probable cause, whatever is required, that evidence also will not be admissible. So any subsequent evidence, any fruit of the poisonous tree will not be allowed. So the poisonous tree is the original bad search, seizure, interrogation. So the original bad thing, whatever the evidence you get immediately, that's the poisonous tree. The fruit of it is anything that's eventually found as a result. An illustration, an example might be helpful. So I'll let you read this while I talk, but let's assume that the police unlawfully enter someone's apartment. I call her Jane Doe in this example. So the police break into Jane Doe's apartment, and they find, as they root through it, so they don't have a search warrant, they don't have probable cause, this is an illegal search. And while they're there, they find her laptop, and they look at her laptop, they look at the files on it, and they find information about a meth lab that she has somewhere else. Think of Breaking Bad and Walter White, and Jesse. They've got a meth lab somewhere out in the desert. If the police now use that information that they found on the laptop to go to a judge, get a search warrant, and they use that search warrant to search the lab, and so all of this now appears legal because they went and got a search warrant, they have what appears to be a valid search warrant, they go, they find the lab, they arrest Jane Doe. Well, not only will the laptop information and anything they found when they searched her apartment be inadmissible, it'll be suppressed because of the exclusionary rule, but also that meth lab evidence will not be allowed to get in, because the only reason the police found it was because they did something unlawful in the beginning. So if the first step that leads them to the second, third, fourth, fifth, and so on steps was unlawful, they can't use any of the evidence from those subsequent steps. That is all fruit of the poisonous tree. So we're not allowing it in. Now there are exceptions to the exclusionary rule. One of them is the good faith exception. And what it says is, if the police made a good faith effort to comply with the law, with the Constitution, we're not going to exclude the evidence. Because remember, they said the reason for the exclusionary rule is to deter bad police behavior. Well, if the police were trying to follow the law and they made a really good faith effort to do so, we're not going to, how can we deter them? They tried to follow the law, so they messed up in some other regard. So for instance, maybe it was just a typo. So for my example here is, the police applied for a warrant to search 123 Main Street. But on the actual warrant, they made a typo, and the address on the warrant was 1233 Main Street. So they added an extra 3. Well, should we throw out the evidence if nobody notices it, and that there was a mistake on the warrant, and they go and they serve the warrant and they find the criminal evidence they were looking for? Should we let the criminal go free because somebody put an extra 3 in the address? Well, the federal government, the U.S. Supreme Court says, no, we're not throwing that out. The good faith exception will apply. And so as long as the police have a good faith effort and they reasonably try to comply with the laws, if there's some little mistake like that, or maybe it's something where the judge made a mistake. Maybe the judge who issued the search warrant said there was probable cause, but when someone raised the issue at trial, another judge said, well, there really wasn't probable cause. The warrant shouldn't have been issued. Should we throw everything out now because the judge made a mistake? Well, that's something that the police tried and thought they were acting properly. They thought if the judge had said you don't have enough probable cause, go back and get more evidence, they probably would have done it. But they were acting in the good faith reliance on what the judge said. Should we throw that evidence out? And again, the federal courts say no. Pennsylvania, as you see here, though, goes a different direction. Pennsylvania has had some liberal Supreme Court justices. So the Pennsylvania Supreme Court, not the U.S. Supreme Court, Pennsylvania Supreme Court, interpreting Pennsylvania's Constitution, said, we will not allow the good faith exception. If there's a mistake in the warrant, even if it's a typographical mistake, you should have checked at police before you executed the warrant. If you're worried about whether there's enough probable cause that maybe a subsequent judge will say there wasn't one, that the judge issuing the warrant was wrong, then go overboard with your evidence. Get more than you need. So the Pennsylvania courts are saying, we really want to protect the people in Pennsylvania. We're going to give them even more protection. We are not going to recognize a good faith exception. So we are one of the few states that does that. Why can states do that? It seems like they're going against federal law. Well, under our concept of federalism, a state can give more protection to its people than is required by the U.S. Supreme Court and federal law, but it can't give less. So Pennsylvania can give more protection, like it's doing with refusing to recognize the good faith exception. It gives more protection to the people of Pennsylvania than what the U.S. Supreme Court requires. But it can't go the other direction and say, hey, you don't need any warrant at all. Go out and search people whenever you want, anytime you want. That would be giving the people less protection than what is required by the Supreme Court. And that's not allowed. So a state can give you more protection. They can make things more demanding on their police. They can't make it less demanding than the federal standard. Fruit of the poisonous tree exception, just real quickly, inevitable discovery. So if that evidence that was subsequently found would have been found anyway, so let's say the body was lying, you found evidence in your bad search that the person had killed somebody, and the body is lying in the middle of Main Street, well, if it's lying in the middle of Main Street, somebody's going to find it. So inevitable discovery, if the police can convince a court that it would have been found anyway, even if they hadn't done the bad search, then the evidence can still get in. Independent source, what that says is, let's say another police unit is investigating this person also, and they find bad evidence, or they find evidence of wrongdoing. If they are acting completely independently of the police unit that did the bad search, the evidence can still get in. So if narcotics is investigating and they do a bad search, and homicide is investigating and they do a good search, the good evidence by homicide can still get in.